Question 301. All of the following are required to be in writing, except A. Real estate sales contract, B. Listing agreement, C. Agency agreement, D. 6-month lease. Correct answer is D. 6-month lease. In California, and most other states, the statute of frauds requires certain types of contracts to be in writing to be enforceable. These typically include A. Real estate sales contract. Agreements for the sale of real property must be in writing. B. Listing agreement. Agreements authorizing a real estate broker to sell property must be in writing, as per the statute of frauds and real estate licensing laws. C. Agency agreement. In real estate, while not always strictly required by the statute of frauds in all contexts, agency agreements in real estate, especially those authorizing the agent to enter into contracts on behalf of the principal, like listing agreements, are generally required to be in writing for enforceability and under real estate licensing regulations. In California, a lease agreement for a term longer than 1 year must be in writing to be enforceable under the statute of frauds. A 6-month lease has a term of 1 year or less and therefore does not fall under the requirement of the statute of frauds to be in writing. While it's always best practice to have any lease agreement in writing to avoid misunderstandings, a verbal 6-month lease is generally considered legally binding in California. Therefore, a 6-month lease is the exception among the options provided, as it is not legally required to be in writing to be enforceable. Question 302. A homeowner renovates his home, doing all the work himself, but fails to pay the provider of his new sinks and piping. This plumbing supplier can file against the owner. A. Writ of attachment. B. General lien. C. Straight note. D. Mechanic's lien. Correct answer is D. Mechanic's lien. A writ of attachment is a court order to seize a debtor's assets before a judgment is issued. It's a more extreme measure typically used in lawsuits. A general lien would encumber all of the homeowner's property, not just the specific property improved with the unpaid materials. A straight note is a promissory note, a written promise to repay a debt. While the supplier might have a note from the homeowner, filing a lien is a way to secure payment by attaching a legal claim to the property itself. Under the law, a mechanic is anyone who provides labor, services, or supplies to improve real property, like carpenters, electricians, roofers, and plumbers. A lien is a legal claim against real property. A mechanic's lien, then, is a legal hold against your property. It is recorded in the county recorder's office by individuals or entities who are owed money for their contributions to improving your property. Question 303. The body of laws created in 1952 by a national commission and the American Law Institute to help regularize the law of sales across the nation is called the A. Library of Sales Codes, B. Uniform Commercial Code, UCC, C. National Sales Standardization Protocol, D. None of the above. Correct answer is B. Uniform Commercial Code, UCC. Library of Sales Codes isn't the name of a specific legal code. National Sales Standardization Protocol. This sounds similar but isn't the official term by the National Commission and the American Law Institute. The UCC plays a crucial role in governing commercial transactions by providing a consistent legal framework across different states. It covers various aspects of commercial activities, including sale of goods, leases, secured transactions, using property as collateral for loans, negotiable instruments, checks, promissory notes, letter of credit. While each state can adopt its own version of the UCC, there's a high degree of consistency across these versions, promoting predictability and efficiency in interstate commerce. Question 304. Which of the following is not true about amortization? A. Over a period of time, the interest portion decreases as the loan balance decreases. B. Over a period of time, the interest portion increases as the loan balance decreases. C. Over a period of time, the amount applied to the principal increases. D. None of the above. Correct answer is B. Over a period of time, the interest portion increases as the loan balance decreases. Amortization is the process of gradually paying off a loan over time through regular installments. Each payment typically covers both a portion of the principal, the original loan amount, and the accrued interest. In the early stages of an amortized loan with fixed payments, a larger percentage of each payment is allocated towards covering the interest charges, while a smaller amount reduces the principal balance. As the loan term progresses and the outstanding principal decreases, the amount of interest calculated for each subsequent payment also diminishes. This is because interest is typically calculated based on the current outstanding loan balance. Consequently, with each fixed payment, a larger proportion is directed towards paying down the principal, leading to a faster reduction of the overall debt. This systematic allocation ensures that the loan is fully repaid by the end of the agreed-upon term. Question 305. California homestead law provides for the following forms of homestead exemption protecting against certain judgment creditors' attempts to force the sale of the home. A. Residential homestead exemption. B. Automatic homestead exemption. C. Declared homestead exemption. D. All of the above. Correct answer is D. All of the above. California's homestead law offers protection to homeowners against certain judgment creditors who might try to force the sale of their primary residence to satisfy debts. This protection comes in two main forms. The first is the automatic homestead exemption, also known as the dwelling or residential homestead exemption. This protection is inherent and arises automatically when a creditor attempts to force the sale of a homeowner's primary dwelling. Homeowners don't need to take any specific action to benefit from this initial level of protection. It's automatically applied to the equity they have accumulated in their home. The second form of protection is the declared homestead exemption. This involves a more formal process where homeowners actively record a homestead declaration with the county recorder's office. While the automatic exemption offers a foundational safeguard, a declared homestead provides additional advantages. These benefits include continued protection of equity if the homeowner sells their current residence and reinvests the proceeds in a new home within a specified period. Furthermore, the formal declaration can create a clear public record of the homestead claim, potentially making it more challenging for creditors to initiate a forced sale of the property. In summary, California homestead law provides a dual-layered approach to protecting a homeowner's primary residence from certain creditors. The automatic exemption offers an initial, inherent safeguard, while the declared homestead provides a more formal and potentially more robust layer of protection with added benefits for homeowners. Both mechanisms aim to preserve a certain amount of equity in the home, allowing individuals and families to maintain their housing stability. The automatic exemption offers an initial, inherent safeguard, while the declared homestead provides a more formal and potentially more robust layer of protection with added benefits for homeowners. Question 306. An owner accepted an offer for the purchase of his home and an escrow was opened. Subsequently, the buyer discovered the owner had made misrepresentations regarding the home's accessibility for internet and phone service. There wasn't any. The contract to purchase thus becomes A. Invalid. B. Voidable by the owner. C. Voidable by the buyer. D. Binding on all parties, if the owner can show that he believed a cable company was going to make service available to all the homes in the neighborhood before escrow was due to close. Correct answer is C. Voidable by the buyer. The seller's misrepresentation about a material fact, availability of essential services like internet and phone, can give the buyer grounds to void the contract. This is because the buyer likely relied on this information when making their offer. A voidable contract is one that is valid on its face but can be rejected by one of the parties due to certain legal defects, such as misrepresentation, fraud, duress, or lack of capacity. In this case, the buyer has the option to proceed with the purchase or to void the contract due to the seller's misrepresentation. Question 307. Which of the following facts should a seller's broker disclose when presenting an offer? A. An offer that will likely be better is going to be presented by a cooperating broker within a few days. B. The Department of Real Estate changed its name to the Bureau of Real Estate. C. The prospective buyer is Asian. D. Both A and C. Correct answer is A. An offer that will likely be better is going to be presented by a cooperating broker within a few days. A seller's broker has a fiduciary duty of loyalty and full disclosure to their client, the seller. This means they must act in the seller's best interests and inform them of all material facts that could affect the transaction. The imminent presentation of a potentially better offer is a material fact that could significantly influence the seller's decision on the current offer. Disclosing this information allows the seller to make a more informed choice, such as waiting for the other offer or attempting to negotiate better terms on the current one. The Department of Real Estate changed its name to the Bureau of Real Estate as a factual change. It's not directly relevant to the presentation and evaluation of a specific purchase offer. It's general knowledge about the regulatory body. Disclosing the buyer's race is a violation of fair housing laws and is unethical and illegal. Real estate professionals cannot discriminate or disclose protected characteristics of buyers or sellers. Therefore, the seller's broker should disclose: A. An offer that will likely be better is going to be presented by a cooperating broker within a few days. Question 308. An agent acting as a dual agent for both buyer and seller in a 1031 exchange does not disclose his dual agency to both parties. This failure to disclose will: A. Provide either party with grounds to rescind the purchase agreement. B. Deny the agent the right to receive a commission. C. Subject the agent to discipline by the real estate commissioner. D. All of the above. Correct answer is D. All of the above. Dual agency creates a potential conflict of interest. Without informed consent, which requires disclosure, either the buyer or the seller could argue that they were not fully aware of the agent's divided loyalties and that this lack of transparency prejudiced their interests. This lack of informed consent provides legal grounds for rescinding the contract. An agent's entitlement to a commission is contingent upon fulfilling their fiduciary duties, which include loyalty and full disclosure. Failing to disclose dual agency is a breach of these duties. Courts and real estate boards often rule that an agent who breaches their fiduciary duty forfeits their right to compensation. Real estate licensing laws in virtually all jurisdictions, including California, have strict regulations regarding agency relationships and the duty to disclose conflicts of interest. Failure to disclose dual agency is a serious violation that can lead to disciplinary actions by the regulatory body. These actions can range from fines and mandatory education to suspension or revocation of the agent's real estate license. Therefore, the agent's failure to disclose their dual agency in a 1031 exchange has significant legal, financial, and professional repercussions, encompassing the potential for contract rescission, loss of commission, and disciplinary action by the real estate authorities. Question 309. The Howards, Bob and Donna, owned a real estate property as husband and wife. When Bob Howard died, his will provided that all his interests should go to his youngest child, Marie. Daughter Marie would: A. Share the entire property with her two other siblings and the spouse, Mrs. Howard, with each of the four individuals inheriting a 25% interest. B. Inherit an undivided 1/2 interest in the property. C. Inherit nothing since the entire estate automatically goes to the spouse, Mrs. Howard. D. Have the amount of her interest decided by the probate court. Correct answer is B. Inherit an undivided 1/2 interest in the property. In California, even when a property is held as husband and wife, it is considered community property. Each spouse owns a 1/2 interest in the community property. Importantly, spouses have the right to will their one-half interest in community property to whomever they choose. In this scenario, Bob Howard owned an undivided one-half interest in the property as his share of the community property. His will specifically directed that all his interests should go to his youngest child, Marie. According to California community property law, Bob had the right to devise his one-half interest in this manner. Therefore, B. Inherit an undivided one-half interest in the property is the correct answer. Marie would inherit her father's share of the community property. The presence of the words husband and wife doesn't automatically create a joint tenancy with right of survivorship unless that specific language is used in the deed. Without the explicit right of survivorship designation, the property is treated as standard community property, allowing each spouse to will their half. Question 310. When the U.S. cost of living index is rising, it will likely be accompanied by A. Rising inflation, B. Decrease in the value of the dollar, C. Rising deflation, D. Both A and B. Correct answer is D. Both A and B. When the U.S. cost of living index is rising, it indicates that the average prices of goods and services needed to maintain a certain standard of living are increasing. This rise in the cost of living is directly linked to rising inflation. A. Inflation is defined as a general increase in prices and a decrease in the purchasing power of money. As the cost of goods and services goes up, consumers need more money to buy the same things, which is reflected in a higher cost of living index. Furthermore, rising inflation leads to a decrease in the value of the dollar. B. When prices are higher, each dollar can buy fewer goods and services than it could before. This erosion of purchasing power is a fundamental characteristic of inflation. Therefore, a rising cost of living index, driven by inflation, inherently means that the value of the dollar has declined. Therefore, the most likely accompaniment to a rising U.S. cost of living index is D. Both A and B. Rising inflation directly causes the cost of living to increase, and this increase in prices simultaneously reduces the purchasing power and thus the value of the dollar. Deflation, C, which is a decrease in the general price level, would have the opposite effect, leading to a lower cost of living index.